Okay, so this is a bit of an ad hoc call, and the purpose of our call today is to share with you the insight around the Employment Rights Bill, which I'm sure you have seen out there in the news and had a chance to grab snippets of. What we thought would be helpful is to go through some of the key aspects of it and answer any questions that you might have. So I'm going to talk mainly and I'm going to encourage you to take notes. I have got a couple of slides, but predominantly I'm going to talk through the detail, but answer any questions that you've got. So I'm just going to share my screen. Just do this. I'm assuming everybody can see that. Unless somebody stops me and tells me you can't, I'm going to assume that we can see that. So the Employment Rights Bill, that's in 2024. It won't actually be 2024, I think, when it gets published. The date will shift because it won't go into Parliament properly. But as we know, when the Labour government came into power, or we're kind of in the process of coming into power, one of the things that they said they were going to focus strongly on was employment and work, and making work how they perceive it to be fairer, to redress imbalances, etc. And the first version, or the first steps to doing that, were published last week. Forgotten what day, Thursday maybe, which outlines the Employment Rights Bill. So that's what we're going to go through. It's important to say that this is a proposed set of changes to employment law in the UK. It is proposed, and the way that bills come into power, they have to go through a series of readings in Parliament. So the bill has been submitted to Parliament. It will go through a first, second, and third reading, which will probably, from what they're saying, happen in the early part of next year. In those readings, that's where it gets challenged. So the other parties, and even from within the party, will challenge and sort of test the bill in the sense of, working out whether it's going to, how it's going to land, whether it's right, etc., etc. So there can be changes at any stage. It then goes into the Houses of Lords, and that's where it gets a reading before it gets what's known as royal assent. Royal assent is when it becomes law. When it becomes law, it will then have a future date of enactment. So you will have heard in the news that the likely earliest point that any of this will become law is autumn 2026. Now, that doesn't mean to say that's guaranteed. Sorry, I'm recovering from cold, so my voice is kind of still a bit croaky. That doesn't mean to say that that's guaranteed. It might be to push things through a little bit quicker. Who knows? But generally speaking, we're going to have a run-in time for this. We're going to see this have a bit of a bit of time for us to work out what it means. It will either replace or it will supplement the Employment Right Act. I think it'll probably just replace it. It'll just kind of come in. So the 1996 Act, is our core piece of legislation around contracts and employment terms. This will replace it. So we're seeing this come in. And the whole premise behind it, the whole basis of this is based on the government's goal to make work pay. So that's kind of what this is seeking to drive. So the areas we're going to look at, and then I'll take the slides away and just talk through these. But the things that we're looking at are changes to unfair dismissal, fire and rehire, 0-hour contracts, flexible working, sexual harassment. When I get to that one, you'll see there's some legislation that is absolutely coming in on the 26th of October, 26, but there's a build on that within the Employment Rights Act. Trade union recognition and how that comes about, and all of that stuff. Day one rights, protection or enhanced protection for maternity, and SSP, changes to SSP. So let me stop. and let's go through them. So what I'll do is I'll go through one and then I'll stop and I'll see if there's any questions. And then we'll go to the next one and see if there's any questions. So one of the first things that we're going to cover, and one of the headline elements, is the removal of the 2 years. So at the moment, under the Employment Rights Act 1996, the somebody has to have 2 years service before they can take a case to tribunal for unfair or constructive dismissal. So that's kind of been in power for, I don't know how many years, but it's a well-established time period. What the government's going to do is remove that. So unfair dismissal will become a day one right, or a day one thing. So from the day I come and work for you, if you unlawfully dismiss me, then I will be able to take a case to tribunal straight away. What that effectively means is that we have to get more robust in our treatment, onboarding, and probationary periods. I'm looking down because I want to get the language right. What is in the Act is that there will be an initial period. Now, that initial period is what we might know as probation. So in that initial period, which we believe will be capped at 6 months, that employee will, have the opportunity to demonstrate their suitability for the role, much like we do now. So probation exists now. It's not as strong in law now as what it will be, but probation does exist. So this isn't new in the sense of probation, but the importance of it, the significance of it, is even more important. So in that initial period, you will still need to act fairly and reasonably. So you can't just decide, oh, I'm just going to get rid of this person. You would have to have due course. So, they're not picking things up quick enough. They've got excessive absence. Their behavior isn't where we need it to be, and be able to measure that and articulate that. But if in that period, that person isn't meeting the criteria, you will still be able to do a probationary exit following your process. Once probation has gone, once they've passed probation, it would then fall into full processes, because it doesn't mean that you can't dismiss somebody. It means that you have to do it fairly. You have to have due course. To be honest, I think this is a good thing. It's one that is often bandied around as being controversial. I do think it's a good thing. I'm just going to have to cough. Apologies. And the reason is, I think it forces us to use our processes properly. If you're acting in line with your processes and you're doing things fairly and properly, it doesn't matter. It doesn't matter where the point of unfair dismissal comes in, because you know that you're not going to be acting in an unfair way. So let me pause and see if there's any questions. You can either come off mute and ask them, or you can type them. So I'll just pause for a second and see if there's any typing. I think this one's been quite well publicised. So in the meantime, we know that this is 2 years away. It is believed that this will come into immediate effect from the point that the bill goes to royal assent. This won't have a future date. It will just immediately be enacted. So probably within 2 years, we will see this change come into force. Between now and then, this is a chance to just really get good at that probation, really get good at how do we bring people on? What does induction look like? Do we set people up to succeed? And that's not just about avoidance of unfair dismissal claims. That's good practice anyway. So getting that really robustly set up. And if you're following that, then there's absolutely no need to worry about this change. So the next one is about fire and rehire. So fire and rehire is a part of law that is very rarely used, in all honesty. It's one to avoid anyway, even when it is legal. But it's basically, at the moment, if you've got a group of people or an employee and you need to vary their terms of employment, and they refuse. So you consult and they go, no, I'm not going to do it. There is a provision in law where you could dismiss them on the Friday, rehire them on the Monday on the new terms and conditions, but keeping their service protected. And that has a lawful element. Famously, this went spectacularly wrong with the P&O ferry situation last year. I feel like it was last year. So we saw this hit the public kind of domain, and there was lots of conversations about it. The proposal is that this will be completely removed, that we won't be able to do that. So it would be automatically unfair, where the reason for dismissal is that the employee did not agree to an employer's attempt to vary terms and conditions of employment. Okay, so it's really quite clear about that. There will be an exception, which is stated in the bill, which how that looks in reality, we don't know yet. But the exception is if it's literally about saving the business. So if the business would fold and would go into administration or receivership, if this didn't happen, then there may be some legitimate cause to do that. But that's going to be few and far between, and you're going to really have to robustly demonstrate that. Any questions? Questions? No? Okay. Just stop me if you have any questions. So we'll move on to 0-hour contracts. So the headline that came out was that ban on exploitative 0-hour contracts. So at first I thought that meant they were just going to ban them outright. They're not. They are going to heavily restrict them. So you will still have a 0-hour contract at your disposal. But there are going to be a number of parts of this. And again, I'm referring to the bill just so that I get this kind of the language and stuff right. So people will have a right to guaranteed hours. So there will be a reference period. So what a reference period means is, and this exists a little bit in case law rather than full law. But if somebody's been working the same hours for a period of time, there is a point where reasonably you can look at that and go, well, that's their hours. They've been working those consistently and at the moment, again, it's not defined, but 6 months to a year, like 6 months onward, if you're employing somebody and giving them the same amount of hours broadly, if it's the odd hour difference, but broadly the same hours every week, then why are they not on a permanent contract would be the question, or at least a fixed term contract. What the government's going to do is be really tight on this reference period. And again, this is one of the things that'll get defined in the legislation debates. But the period that's been mentioned and is referred to in next steps is 12 weeks. So the likelihood is you will be able to put somebody on a 0-hour contract for 12 weeks, which kind of covers like a summer period or a seasonal element. But if that person is going to be working with you for more than 12 weeks, then it may be that a 0-hour contract is not legal, is not kind of the right approach. So the other thing that we think is coming in with this is if you put someone on for 12 weeks and then go, all right, we haven't got the hours, so we finish the 0 hours, we don't put them on permanent. And then a week later, you bring somebody else in and put them on 12 hours, on same hours for 12 weeks. Then that again would give rise to a tribunal. So it's about using the right contract types. So I think what we'll see is that in this, you need to think more carefully about if your business has 0-hour contracts in it, how do you use them? Are they legitimate? Are they kind of achieving the goals that you need them to achieve in terms of that real variability? Or actually, would a fixed term contract work better? The other option is to do things like annualized hours. So it might be you need somebody for the full year or for 2 years or permanently, but what you don't have is the same number of hours every week. like, I don't know, say you are a holiday park, you need them to work much more hours over the summer, fewer hours over the winter. One of the options is to work an annualized hours contract. So you would group up all of the hours. So say, for example, it's 20 hours a week. You would group up the 20 hours a week across the whole year. I'm just gonna have to cough. And then you would have that as a bank of hours, and you would then spread them out over the year at a variable rate to allow you to have the peaks and troughs. You would then, so there's two ways to pay it. You could either pay it based on the number of hours the person works in that month, or what's normally done is you would pay an equal amount every month, but you would be sort of banking the hours. Again, you've just got to be careful that you don't end up where, you know, you've been paying them for hours that are banked and then they leave, and how do you get that money back and stuff. But, we can help you with that if need be. The other thing within 0 hours, and then I will pause to get any questions, is at the moment there's no statutory right to notice of shifts and shift cancellations and things like that. That is going to be rectified. So the bill will introduce what it's calling a reasonable notice period of a shift. And that will include time, day, and how many hours are to be worked. There will also be a right to reasonable notice to a change or cancellation of a shift. The reasonableness, I think, is one that will be debated, and the reasonableness will also have an element of contextual to your business. So I think we're going to need to see how that conversation pays out as to what is reasonable. But it may be that if you have to cancel a shift short notice, you would still have to pay the person. You'd have to define that, I think, in your policy. You'll have to have a policy about this that really defines the notice period and cancellation and all of that stuff. So it's going to get a lot tighter. The circumstances under which a 0 hour contract might be applicable and legal will change, is basically where we're at. And I don't think many businesses will use them moving forward based on that. So let me just read this question. How do holidays work with 0 hour contracts and variable hours per week? And what is the notice period? Submit someone. Right, so two questions. So how do holidays work with 0 hour contracts and variable hours per week? So with 0 hour contract, it's worked out in averages. It's worked out over over a kind of a reference period, and you work out the average hours worked and work out the holidays from there. And we can help you with that in terms of going through the calculation in detail. It's a bit of a pain in the backside, I'm going to say that. But once you get your head around it, it's just about, working it out. The notice period for cancellation of shifts at the moment, there isn't a statutory right to cancel a shift. So most organisations, I think, would be fairly reasonable. But there isn't that you could cancel it straight, with an hour to go and not have to pay that person. And this is why I think there are going to be a lot of heavy restrictions on 0 hours, because if we think about stability and, if we think about engagement in your business, we think about people's kind of well-being and all of those things, not knowing when you're going to work and not knowing whether a shift's going to get pulled at the last minute impacts somebody's ability to pay the bills and food on the table and all of those things. So I can see why they're bringing these restrictions in and these kind of things in. But at the moment, there isn't a cancellation period unless you've defined one in your policies, which you would have to then stick to. Okay. Any other questions? The thing with Zoom, I don't know whether somebody's chat because it doesn't have the little. Oh, here we go. Okay. So yeah, so that's a comment about. Okay, that's not a question. That's a comment. So I'll come back to that one. Yeah. Okay. So yeah, and 0 hour, 0 hours. I think strategically, if you have 0 hour contracts in your business, now is the time to start strategically reviewing them. So look and thinking about is when this legislation drops in, are these legal? They're legal today. So it's not saying that there's anything wrong with what you're doing today. It's like, will this be legal? And what might we need to think about? How might we need to think differently about how we engage people? How might we need to think differently about what we put onto 0-hour contracts and what we don't? All of those things, were are important to do. We have students that let us know when their availability is. Yeah, so if you've got 0 hours the reason why we have 0 hours is because the flexibility does work both ways. That will have to come out the bill around. They'll need to give you notice as well. I would imagine it'll be mutual. It can't just be one way. There will probably still be a degree of people, if they're on a 0-hour contract, letting you know when they're available. And this is where the 12 weeks will fit perfectly, won't it? Like, I'm back from university in June, I'm available till October, and I'm available for 30 hours a week. What have you got? And then you would say, yeah, we've got this. We'll put you on a 12-week 0 hours contract, and that's perfect. Like, there's, unless something changes, there's nothing nothing legally wrong with that. So yeah. Okay, the next one for us to cover then is flexible working. There is going to be quite a significant shift in flexible work. And so we already know flexible working is a day one, right? That has already changed. At the moment, it's not a kind of an automatic right, if that makes sense. So you apply for it and you would review it and you would say yes or no, and you would give a reason if you say no, and you move forward from there. The way it's going to work is it's going to shift that dynamic a little bit. So your grounds for refusal are going to be much slimmer. The business reasons, so the reasons why you can refuse, will remain the same. So in some ways, it doesn't change. But if you're so I've worked with people where this is more in kind of the charity work that I do with people who have MS. So I've seen people who have worked all the way from home during, say, for example, COVID. They have been able to fulfill a role, they've been able to do it, everything's fine. And then they're back in the office. They then apply for flexible work and to be able to work from home some a part of the time, and they get refused that. Now, that even today is wobbly because, well, we could do it. So there's no legitimate reason not to, unless, obviously if it's a shop or something, it's very different. But, there's a question mark there, isn't there? But at the moment, there's still probably more scope to go, no, like, we want people to be in the office, etc. That will shift. You will have to have a very reasonable reason for refusal. And that's kind of what that's kind of what we're expecting. What will come out when the regulations get drafted, so the flexible working regulations, is the steps that need to be taken before anything is refused. And it might be that as part of that, there has to be trial periods and stuff like that, and consideration of, is it technology that's in the way? Like, what is it that's getting in the way? And remember, I've used home working as an example there, but flexible working is way beyond work, and it's all the nuances of it. Any questions on flexible working whilst I have a drink? I am sorry that I'm trying. No? Okay, we've got to keep going. If you've got them in the pop-up, I will pick them up. So sexual harassment then. So this is an important one. So sexual harassment from the 26th of October, so this is definitely coming in. You have a duty to prevent somebody experiencing sexual harassment at work. And to be honest, again, it's not that that's never been the case. It's just really enhanced and amplified and looked at. And if you fail your preventative duty, The recourse is 25% uplift on a compensatory award at a tribunal case. The bit that comes in that is more challenging to manage, in all honesty, so you need to think about this and have this in your policies, is about the third party. So if a third party sexually harasses, no, sorry, the 26th of October 2024. So this is coming in this month. In a, when is that? A week's time, 10 days time? I've lost track of what day it is. In the month. If a third party subjects your employee to unwanted behavior, behavior that makes them feel uncomfortable, derogatory behavior, all of those different things, and you haven't taken preventative steps, then legally your employee could take you to tribunal for that. Okay. So what does that mean in practice? It means things like, if you have visitors, do you share with them a policy? If you have suppliers that you engage, do you require them to show you their policy around that? Or do you have them sign something that shows that they understand that they're not to, do anything that could be constituted that way? And remember, sexual harassment can be things like wolf whistling and making comments and, things that happen and people think are okay and they're not. So people might be in a mindset going, well, that's just whatever, it's this banter, it's, that famous word that always comes up in these conversations. And it's not. And you have a preventative duty to stop the third party doing that. Obviously, if it happens, then it's how you react to it as well. So say, for example, a delivery driver comes on site and makes some inappropriate comments to a member of your staff. That member of staff feels really uncomfortable and they report it. You need to show that you've taken action. Now, you can't go and discipline that member of staff, but you would be going back to, the delivery driver member of staff. But you would have a duty to say, right, let's make sure that this member of staff isn't there when the deliveries come. Let's report it to the delivery company and request that driver doesn't come to our site. Let's, request that they do something about it. So you've taken as many preventative steps as you can to detract from, to stop that happening. So that's really, really important. Members of the public are third party. So if, for example, you are a service provider where public is coming into your place of work, and those members of public are acting inappropriately to staff members and they feel uncomfortable, and yes, the staff member could raise a claim to tribunal unless you can demonstrate that you've taken preventative steps. So it comes to, I don't know, let's just say they're a member of your organization. So they come in and you get them to sign something to be a member. Then in that case, you would put it in the membership agreement that they know that they're not to do these things. It's about, what you publicize. You might have things on notice boards. You have to judge it, don't you? What's okay. You might brief your staff around it as well, so they know to take preventative steps. So, if there's a manager and you're in a shop and a customer's being inappropriate with a member of staff, that the manager intervenes and stops that. And ultimately, in its worst case, that you would ask that customer not to come back in its worst case. So it's different for each organization. And if you want any detail about how it might fit contextually, then let's talk about that one-on-one, because I think there's lots of different contexts. So the message that's come through directly, let's pick that one up, because I think that's an important one contextually to the industry that you're in. So the law will say reasonable steps. Does that mean it will never happen? It might happen. What you're doing is taking reasonable steps to prevent it happening, so that if it did happen and they would raise it and you would respond to it, you'd investigate it, you'd deal with it. If it got to tribunal, you can demonstrate you've tried to stop it, you've got policies to stop it, you've responded to it appropriately, and you've done everything you can to stop it, is ultimately it. So the bill, so now I'm in the employment rights bill, I'm not in October 2024, forgot what year I was in. The bill will expand that to all harassment. So it's good practice now to just think about third-party harassment across the board. Like, how do we prevent third-party harassment? It could be on, sexual harassment, but what about harassment based on disability, on age, on all of the characteristics? Okay, so let me just pause for questions and a cough. So it's good practice to sort of use this legislation coming in now and saying let's just really think about third-party harassment in its broadest context and what that looks like. It does sit slightly different when it comes to race as well, because with race and active harassment on the basis of race does potentially give rise to it being criminal. So I worked with a membership organisation for a retail sector, so lots and lots of retail businesses working with this governance sort of membership organisation. And one of the things we sort of worked on and looked at is, at what point does racial harassment become abuse? And at that point, that needs to be reported to the police, because it is a criminal act, not just a, there's no just to it, but it's not within this act. It's a criminal act. And obviously the scale of the other forms of harassment may well be as well, but be aware of that in terms of the race element, because it's important to have that defined. The other thing that will come in as part of the bill, so again, I'm in the bill, I'm talking 26, is if somebody raises harassment. So at the moment, I can raise that I've been harassed, and I would probably raise that through your grievance policy, and you would respond to it and deal with it through your grievance policy. The Act will propose to move any report of harassment to be a protected disclosure, so whistleblowing. So it'll move it into your whistleblowing policy, which, broadly speaking, it's the same. You would look at it and you would investigate it and you would respond to it. But the recourse for it is bigger within whistleblowing. And you have to sort of look at it through the public disclosure side of it as well. Even though it's not public, it's considered, protected disclosure. You have to think about it as it could go public. So it's a protected disclosure. The other thing that they are going to amplify through the Act is there's parts of the Equality Act which have never come into force. So one of the things that is cited in the Equality Act but has never ever been used is around dual discrimination or combined discrimination. So intersectionality, we know, is a big topic in the inclusion world. We're never just one thing. We're a blend of lots of different things, and some of those blends might be protected characteristics. And we may be experiencing discrimination because of a combination of two things together. So sometimes this, I might be getting discriminated against, and I might say it might be linked to my sexuality and my religion. And those things in isolation aren't the thing. It's the combination of them and how somebody else may then discriminate against me because of their perception of that and whether they think that's right, wrong, and whatever it is, and therefore I get discriminated against. That bit has never really been properly enacted. So we've always talked about intersectionality, but in law you would normally be going down one of those routes and then using, like, you'd almost have two separate elements. We're going to see that come out more strongly, so that will be more enacted as we move forward as well. So be aware of that. It's kind of the nuance of inclusion, and it's about the complexity of inclusion. To be honest, it's in force now, but I think we'll see more focus on that as we move forward as well. Any questions on that? Am I cheering you all up? Is everyone having a fabulous time? Is everyone crying softly into their prawn sandwich? Okay. So next one I want to talk about is trade unions. What we know is that the Labour Party are pro-union. We know that there's strong allegiances with unions, and we will see that now reflect across into employment. So the right of trade union access will be enhanced. So we are expecting to see, and again, we don't know the nuances of this, but we are expecting to see that the bill will give trade union officials wider right to access workplaces for recruitment, organising, and collective bargaining, not not industrial action, just the general course of trade union and trade union work. Following a statutory process, and we don't know what that process is. So if they believe in your workplace there is enough percentage of people who would like to be part of a union, there will be statutory provision that will enable the union to recruit and work collectively within your organisation. And that, and that opens up a whole different kettle of fish around negotiations with unions and how that all works and collective bargaining and things like that. We won't go into that on this call, but it might be that as we get more clarity around this in the coming year, we will have a specific call about that. The thing with this is once the bill passes, the trade union work will come into secondary legislation. So it might be once the bill's passed, they'll then have to put legislation around that, the trade union side of things as well. So this one is likely to be one of the later ones that comes in, just to sort of put your mind at rest with that. One thing that will come in though, and I think this will come in as kind of as soon as the act comes in, is you will be obliged to notify employees of their right to join a union. Everybody has a right to join a union today. Like nobody is stopped from joining a union. I can go out and find a union and become a member and pay my money, and then if I have an employment issue, I can get their advice, and they might even accompany me and all of that stuff. All of that exists today. What we don't have to do is point that out to people. We don't have to make a big deal of it. Under the legislation, within your employment contract, you will have to have a section around trade union, that they have the right to be a member of a trade union. At the moment, we only really do that if it's collective. Like if it's recognized, like a unionized workplace, there's a collective agreement in place. But it looks like we will see that come in. The other thing that is likely to come in with the union stuff, in this secondary piece of legislation, is the kind of really focusing on how do they empower the unions, is all of the restriction to industrial action that the Conservative government has brought in over the last however many years is likely to go. So we will see more access to industrial action, more industrial action happening. Again, I'm not going to speculate on that because we don't know what that's going to look like in terms of the ballot, in terms of how that would work and all the rest of it. But that's important. And, along that side, that will be protections for workers around the trade union work. So let me pause and see what questions we've got, if any. Any questions? Okay. So I'm going to move on to time off. So the thing with time off is going to be covered in specific elements, but fundamentally, most of the things that have a qualifying period. So at the moment, there's a qualifying period for me to access maternity, paternity, shared parental, all of these different things. So where you have a qualifying period, normally 26 weeks, that will remove. Things will become day one rights. So we are expecting to see all aspects of parental leave, so whether that be adoption, maternity, paternity, shared, all of that, to become a day one right. So from day one, I'll have access to that. So removing the length of service requirement to it. We're also expecting even more enhancement on protection for maternity returners. I'm going to read this bit out. So the bill will give the powers to introduce regulations to cover other dismissals which are not redundancies. So this year we've seen more protection for people on maternity leave or returning from maternity leave around redundancy and the 18 months coming in and all of that stuff which we've talked about in previous calls. That will be expanded to other dismissals which take place during pregnancy, maternity leave, or returning to work. And that will also take that will also apply to other forms of family leave such as adoption, shared parental, neonatal care leave, and bereaved partners parental leave. It doesn't, we don't know yet what it means, but in the explanatory notes, it does say that the dismissal of women who are pregnant on maternity leave and during a 6-month return to work period will be covered from, will be restricted from dismissal, except in specific circumstances. And it doesn't yet say what those specific circumstances are. So I imagine if it's something major, like it's a safeguarding or it's fraud or it's like your gross misconduct stuff, I imagine you're still going to have the ability to act around that because you could not. But if it's about performance or attendance or any of those aspects or things that might be less gross misconduct, more misconduct, then it may be that we simply can't dismiss somebody who is pregnant right up till 6 months after. But that could change as well. Remember, this is just proposed. The other thing we're going to see is the right to bereavement leave. So at the moment, bereavement leave, other than parental bereavement leave, is at your discretion. Most organisations offer bereavement leave, but that's going to become a day one right. It's going to be at least a week as proposed, and it's going to be like a right, like they can take a week off. The regulations will have to define, we don't have it yet, the necessary relationship in order to qualify. It's probably going to mirror the stuff that's already out there, but yeah, we need to get the precise detail on that. And I think that's it. I'd be pleased to know. Oh, one more. Statutory sick pay. We're expecting to see a reform into SSP. This is quite a big one, actually. Oh, one more thing. Statutory sick pay will become a day one right as well. So instead of waiting till day 4, people will be eligible for SSP from day 1. So massive financial implications. It's worth doing some strategic looking at that. What would that cost? What might that look like in terms of budgeting, etc. But it also means that you need to have your absence processes really robust as well. Looking for patterns, making sure people aren't taking advantage of it. And then that's not negating the fact that there will be genuine cases where people are off sick, of course. So let me see what questions we've got. That's all I'm going to cover today. Probably thinking that's quite enough. Thank you very much. But what questions or thoughts or reflections do we have? You can email me them, not email me, chat them. I'll give it a couple of minutes just in case anybody has got any. I think the main message we would give around this is don't panic. It's at least 2 years away. So that's kind of the first thing. Like none of this is coming into force quickly. And in balance to that, start thinking about it now. Regardless of the details that get shifted along the way, we can see clearly the trend of kind of where the thinking's going around employment. So making sure your processes are robust, making sure you're following your processes, making sure that we've got things in place to support people to succeed, and we're having conversations and we're doing all of those things. All of that is really, really important. The importance of having, doing really good one-to-ones, the importance of, following up with return to works and how to do those, the importance of probation reviews and how to do those properly. It like that's not new. They've always been important, but there's more at stake, is what I would say now as we move into this new legislation. We are actually, I'm sure you've received information, but we are actually going to be running some training programs, some open training programs, specifically around some of these things, helping employers get their house in order so that when this stuff lands, it doesn't matter because you're doing it anyway and you don't need to worry about it. So if that is of interest, do shout. I believe you will have received information. I haven't had any messages through chat. Does anyone else have anything they would like to add or ask before we finish? Hopefully I haven't upset everybody too much. I much prefer doing the ones where we're talking about fun stuff and how we develop people and all of that stuff. But yeah, these changes are going to be significant. We will, with our monthly sessions, we'll cover these more in depth as we get more and more information on them. Like I say, the key thing is don't panic, but start to think about how do we start to move towards these now. And the 26th of October, sexual harassment one, that one is coming in the next few weeks. So be aware of that. Okay, then, if there are no questions, we will finish here. And if you've got any questions on the back of it, obviously contact your account manager and we'll answer the best we can. Obviously, some of the bits we simply don't know until the acts are published properly. But yeah, we'll help as best we can. Thank you very much.